Hi friends, welcome back to my channel Shruti Desai's lecture on law. We are learning mediation. Before starting today's lecture, I request all of you to subscribe for this channel and also click on the bell icon. You can also read my book on alternative dispute redressal on Amazon Kindle, which is in digital form. There is no physical form book available in my name. If you want to know more about me, do visit my website www.shrutidesai.in/. Now, last time I told you friends that we will learn today the joint session and conduct of joint session. Mediator has to, be a very good listener. He should be calm and composed because the parties before him are litigating since maybe decades or for a long time. So they have more of representations and they have more of agitations. They want to outburst. So it's basically he has to play psychological counseling. It is more of psychological counseling, and he has to understand even the body language of the parties. Now here, how it is to be conducted. He will give opening statement. He will clarify that both the parties. You tell me who will start first. If it is court next mediation, usually the petitioner or the plaintiff starts and defendant responds. He also has to ask the advocates along with the parties how long they will take, so that he will understand. He can have the brief idea of a number of hours spent on this mediation. Thereafter, the party outburst. During this process of outburst, we will come to know the area of agreement, area of disagreement. During this process of discussion, suggestions are also given to resolve the area of disagreements, and parties have to think on this independently on areas of disagreement, and the suggestions are given. After this opening statement of the parties are over, then one by one, it will be one by one. Usually they also fight at the same time, but then you have to handle the situation. In this case, then once a party finishes, he has to ask more questions. Would you like to add something more? Do you remember anything more on this case? Anything more you want to represent? Something is not left out. So if you ask such question, there may be chances that something more come out, or that there may not be anything more to say by the parties. In this joint session of the parties with mediator, we also come to know the personal information which may be very vital to settle the matter. In this, mediator may, when the parties complete the representation, the areas of agreement and disagreement, mediator can take down the points of agreement and disagreement, and also the suggestions given. He will say that, okay, now these are the suggestions, both of you go and think over it. It's very good for you. You are litigating so much, you have spent so much of money, energy and time. You don't give this inheritance to your children, so it is better that you settle this issue and start a life afresh. In this, while winding up the joint session of the parties, mediator has to recite whatever has been negotiated or whatever has been discussed in front of him in that particular session. Now, a mediator may recite even the prior history of negotiation. Suppose it is the second joint meeting, then in that case, mediator has to also recite the prior negotiations, what had happened, just to refresh the memory. And mediator may ask for a copy of evidentiary papers to understand the dispute. Of course, he can ask, and counsels again, they have to say that how long they will take. Now, in this also, once the more and more information is generated, mediator will be at ease to arrive at, to bring the parties together. After listening to one party, A and B, both the parties are in front of him. So after listening to one party, he has to communicate. eye to eye contact. Here we have seen in courts there is no eye to eye contact. In arbitration there is, but it's a sort of a court and it's a litigation. Here it's more of psychology and understanding the nature of dispute, and there is a personal communication between the mediator and the parties. So here, after one party finishes its representation, it is always mandatory for a mediator to repeat what he has said. You said this, I repeat, this is your points of agreement. I repeat, these are the points of your disagreement. We negotiated on this aspect, the method of settlement, and am I wrong? Do you want to add something to it? Have I missed out something? These are the questions while concluding the joint session of the first party. Thereafter, the second party would start. The same way, the method will go, and at the end of it, when the second party finishes, once again, mediator has to repeat, you said this, these are the areas of agreement, there is no dispute, these are the areas of dispute, and you also suggested this for settling the disputes. Tomorrow, we will learn more on mediation. Till then, see you.